So I wanted to start, first of all, with a little scheduling update. On Friday, my colleague, attorney Mike McGurk, is going to come in and give a presentation based upon the pitfalls and trials and tribulations and traps for the unwary inventor, student inventor, and entrepreneur, especially in a small startup. I've had a lot of questions before and after class about joint degrees. Mike has a joint degree in law and in engineering. He used to be a patent examiner for the United States Patent and Trademark Office, and then he went to one of those giant Engulf and Devour law firms, which will remain nameless because I don't advertise for Engulf and Devour law firms. But he went for one of the really great white shoe firms, with offices all over the world, and prosecuted patents mostly for them. And now he's out on his own and we work together on some cases. I don't know anybody better because he has both the experience from his work at the USPTO and his work as an attorney. I don't really know anybody better to do cases with, especially cases that involve patent prosecution. So bring your questions, bring your issues, and all of your concerns will be addressed. Whether they be about intellectual property protection or even careers. Mike is just a great guy, and we're lucky to have him come in. I wanted to sort of back up just a second in terms of review and go over just some things I didn't get a chance to last week about these run fins. Here is the abstract of the invention. Remember the sawed-off swim fins with the doggy bowl bolted to them. This is actually from the provisional patent application. Again, not rocket science. It's just a description of what the thing does in sort of engineer speak. But this is just a typical abstract from a provisional patent application. And if you want to know whether the illustrations in your provisional patent application have to be complicated, here's the illustration that was sent in that was approved by the United States Patent and Trademark Office for this provisional application. As you can see, if you have a ruler and a clean surface to take a photograph with your camera, you can get a provisional patent application. Not complicated stuff. But of course, this being MIT and Alex Slocum being a prolific inventor, if it can be made complicated, he'll do it. And actually, this is kind of a good thing to do because, as we talked about, if you later want to convert your provisional to a non-provisional, or if you want to file a non-provisional based upon your provisional patent application, it's good to get some of the stuff done, the hard work done up front, whether it be illustrations or, in this case, computational fluid dynamics. Now, I know Kim Blair used to run who was in the sports innovation group here at MIT, used to be the computational fluid dynamics person here. I don't know who does it now. Obviously, the wind tunnel is not working at the present time. But this was, in fact, this is what replaced in many ways the wind tunnel. And Alex, I think, just to show that he could, included this with a provisional patent application. But as we said, this is not necessary. But I imagine that when the claims examiner came across this and saw MIT, I'm sure that it sort of moved the provisional patent application along. Again, if you can include things like this in your provisional, simply because you have the technical expertise to do it, it's one way of separating yourself from other applicants who only have a camera and a ruler. anyhow, I thought you'd like to see that stuff. And here's this is the prototype after it's been developed. This is one of the advantages of a provisional application. If you have a pair of cut-off swim fins with a dog bowl, water bowl bolted to the bottom, and have in your mind that you're going to be developing this prototype over the course of the months ahead, especially if you can get some funding from mom or dad or your friends or from crowdsource or from some a funding group, some venture capital group. It's good to file a provisional because then you can develop the upside down water bowls attached by a bolt to a cut-off fin and come up with something like this. You know, if you can take that prototype in, I'll give you an example. You take the prototype into a manufacturer, usually they're in places like Korea, South Korea, or Vietnam, and you sit down with their engineers, they'll do a lot of this for you. But having filed the provisional, okay, gives you a whole year to commercially exploit and to develop that technology while you own it. And so you can go out and get funding, you can go out and publish it, you can go out and get customers, you can go out and get a manufacturer, you can get together with engineers at the place where you're going to have them made or produced, and eventually you can do all of this on somebody else's dime. All right, so that's what the provisional actually is helping inventors to do. It gives you breathing space to get some money. Yes?
So I have a question. Since Alex is a professor at MIT, did he have to file this? Is this through the TLO that he did this? Or how does it work if you have an invention and you're a professor?
But believe it or not, professors have lives outside of the university. So the only thing that MIT would get a piece of, okay, is if there was an invention either by a grad student or a professor that was funded by some other source. So if the Office of Naval Research comes in, you'll recall the example that we talked about on the first or second day of class, and they fund your research, and you come up with a hydrogen generating machine based upon research that you did in this particular class, directed research, then in the provisional patent application or in the non-provisional application, depending upon which way you go, there's a box where you have to certify that no government funds were used, or if there were government funds used, you need to disclose it. And in those cases, where the invention was developed with someone else's funds, either private or public, then they could very well have rights. When you go to work for Adobe, or you go to work for Google, or you go to work for Microsoft, or you go to work for IBM, they stick an agreement under your nose. It basically says, we own everything that you think of while you're employed by us. And by teaching or doing directed research at MIT, you agree to abide by the rules in the student handbook on that. And MIT does get a piece of the action if it's directed. However, if you go to the dumpster after class and you find some waste that's been disposed of, and you on your own time use these materials to develop some invention like a hydrogen generating machine, you own that, okay? So long as it doesn't involve substantial MIT resources, you own it.
What about in this case where Alex is paid by MIT to teach classes, and it looks like he's used some software that perhaps, like SolidWorks or CFD software, that perhaps originated license-wise from MIT?
Mm-hmm.
Do you have a claim to it? How does that work?
My opinion would be no, okay? Knowing Alex, I think he probably has someone that does computational fluid dynamics, and he might even have software on his own. But even using software that is, somehow licensed by MIT after hours in a setting that's not directed by the institution, he's not being paid, to do something for the institution. I think he owns it. It's kind of kind of like our student using a sink at MIT to clean off the spheres that had shown that they had chemically reacted with the water that they had been in the gallium indium solution that they had been immersed in. That in my view is not substantial MIT resources. Again, in the law, it depends. It depends. Every case is fact specific. Okay, so the more involvement there is, the more likely it is that they might have some interest in the invention. But from what I know about, I know of no program at MIT that is focused on aqua. What do they call them? Aqua runners. Maybe there is. I don't know. But I think he thought it up all on his own. Anyhow, so we've already talked about a lot of this. Some of the advantages of provisional patents. First of all, to recap, you have 12 months. Okay, so that's breathing space, during which time you can do anything you want about disclosing your technology and not have to worry about a thing. In fact, it's always better to file the provisional before you do any disclosing, thinking ahead, of course, about possibly getting intellectual property rights in another jurisdiction, in an absolute first-to-file jurisdiction. So that 12-month grace period is just great. And it's wonderful for academics, too, because you don't have to be afraid of publishing a paper and losing your intellectual property rights to an invention. You can file a provisional and publish away, and you own it. Nobody can take it away from you. If you disclose before, of course, as you know, you have 12 months. So if you make a disclosure and then still file a provisional within a year, you're okay, as long as you don't try to get protection in an absolute first-to-file jurisdiction. Yeah.
Wait, so can you explain that? Because I thought it was if you disclose before you file provisional, you have 12 months for the real patent.
Yeah, that's correct.
Okay.
Remember that the American Invents Act gives all inventors a 12-month grace period, okay? And so that means, as opposed to absolute first-to-file jurisdictions, so long as your disclosure comes within a year of the date that you file the provisional application, you're okay.
So we can disclose and within 12 months file the provisional.
That's right. But if you're trying to get protection in an absolute first-to-file state jurisdiction, you're out of luck. Okay? So we are a first-to-file, except when it comes to the grace period. So remember the example we had? In May, A conceives of an invention and publishes it. And in June, B independently conceives of the invention and files a patent application. Because we're first to file and because we come under the AIA, then A gets the patent. When A, even if it's 11 months later, goes to the USPTO and files the provisional application, the USPTO will grant A the patent. And if A were to go and ask the USPTO to cancel the other application, it would have to do so, unless, of course, they had complied independently with the AIA by making some sort of disclosure within that period of time. So, it's that 1 year grace period is great, and it's wonderful, as I said, and was put in there for academics, so that you can publish and not worry about losing the rights to the technology. So converting a provisional to a non-provisional. Okay, so we sort of know the difference between a provisional and a non-provisional, correct? So a provisional patent application is really simple. You don't have to have, complicated drawings. You don't have to have a claim, but you should have a claim. As long as you disclose the invention, describe it, include an illustration, and fill out the cover sheet and pay the $148 filing fee, you're probably going to get it, all right? So the difference between that and a non-provisional application is really quite significant. You know, in a non-provisional application, you have to have claims, very detailed claims. In a non-provisional application, you have to have detailed engineering drawings or illustrations demonstrating the invention. In a non-provisional patent application, you have to do a study of the prior art. So all of these things cost money and are much more formal in the non-provisional setting. And so oftentimes inventors like to go the non-provisional route in order to save what? Money. You know, a very simple non-provisional application can cost easily $10,000. You have to hire an illustrator, you have to hire a lawyer to write the claims section, you have to pay a higher fee to the USPTO. You know, it's a much more formal process, takes a lot more work, and can be, in some cases, with a complicated invention, prohibitively expensive. That's another one of the advantages of going the provisional route. It gives you a year to line up your ducks. As I said, get money from family and friends, or crowdsourcing, or from somebody, some entrepreneurial group that's interested in your technology. Then you don't have to lay all that money out yourself. I don't know about you, but you know, most people aren't independently wealthy and don't have a lot of money to throw around on these things. Especially if they are intent on licensing the technology to somebody else. Why put up all of the front money? Why take all the risk when you can let somebody else take the risk by licensing your technology, so long as you can get them interested in it? Anyhow, some of the things that you need to know about converting a provisional to a non-provisional. And by the way, it's not done that often. One of the problems with converting a provisional to a non-provisional is time. Of course, a utility patent is good for how many years? Yes, 20 years. Design patents, 15 years. But yeah, 20 years. And so you want to own that technology as long as possible. And the thing you don't want to do is lose any of that time. If you convert a non-provisional to a provisional patent, then what the USPTO does is they go back to the original filing date when it comes to issuing the patent. So you lose a year. It's easier to just file a brand new patent application and based upon the provisional. You simply cite the provisional. Sometimes you'll cite 2 or 3 or more provisionals in your non-provisional application. So it's better to just let the the provisional patent lapse, and instead, before the 1-year anniversary, file a non-provisional application. That way, you just don't lose that 12 months. And under the AIA, a provisional patent application can be filed up to 1 year following the date of first sale, offer for sale, public use. This goes to your question. Or publication of the invention. Remember that these pre-filing disclosures, although protected here in the US, create problems in absolute first-to-file jurisdictions, okay? Advantages of a provisional. Simplified filing, establishes the United States patent application filing date for the invention. Provisional patent permits 1 year's authorization to use, patent pending. And by the way, why would I want to use that? Why would you want to be able to say something is patent pending? What are you doing when you say that? Yeah, aren't you really sort of announcing to the world that you're the owner of this technology? And if you want to commercially exploit this technology, you got to come and talk to me. And you're allowed to do that when you file the provisional. Because the fact is, you own it. You own it. And so everybody has to come to you. That's basically announcing to the world that you are the owner of the technology. A provisional patent begins the Paris Convention priority year. Again, that has to do with the recognition of your intellectual property rights in this and other jurisdictions, and it enables immediate commercial promotion of the invention like I talked about. Finding a venture capital group that's interested in your gene editing technology, finding a venture capital group that's interested in your aquafins or your better mousetrap or your software, okay? Your agricultural, you've come up with a new potato for Frito-Lay. It gives you that time to commercially exploit. And by the way, you know, Alex doesn't do these aquafins for fun. You know, what do you think he was doing that for, right? You know, Alex, I'm sure, had visions of everybody across the nation, you know, in a pool using his inverted water bowls and swim fins, you know. Imagine 1.3 billion Chinese wearing your, you know, your aqua blades or whatever they're called. You know, the idea behind all this is hopefully to commercially exploit, you know, your inventiveness. All right. A provisional is not published by the USPTO. I think it's important to remember that. And so it doesn't constitute a disclosure. So, you know, in a way, it remains, it's yours, but it's secret. So there's no competition, okay? Nobody can go to the USPTO and look up your provisional as part of a prior art search. They can look up a non-provisional, but your provisional application continues to keep your technology secret. It takes the USPTO 24 months anyhow to issue a provisional. So oftentimes, you know, it takes so long in there that you don't have to worry about anyone or any disclosures by people going on their site. It allows you to get USPTO certified copies. Why is that important? Well, you know, investors are going to want to make sure you're the owner of the technology. They're going to ask you to prove that this invention is yours before they give you $1 million to produce these things in some factory in Southeast Asia. Provisional patent allows for the filing of multiple provisionals for patent and consolidating them into a single non-provisional application. If you take the aquafins as an example, or the spiky ball as an example, you know, you can take those things into their component parts and break them down into different patentable technologies. So you could file, for instance, a provisional on the shape of the bowl attached to the fins. You could file another provisional based upon the upper that goes onto the foot, and then at the proper time within a year, file a non-provisional that incorporates both provisional technologies. Yeah.
So you mentioned the provisional takes a while to be issued.
Yeah.
So let's say like I file a provisional, I have within 12 months to file a full patent.
Right.
But theoretically I'll hear back about the provisional while my full patent is also being
Yes. Well, obviously what happens is, the important part is the filing with the USPTO, okay? So you can get the certified copies so that you can use patent pending so that it's on file someplace, okay?
So you can get a certified copy of the application for your provisional.
And the receipt of the application, okay? And sometimes you hear from the USPTO fairly quickly. Not often, but you know, depending upon the complexity of the invention, it could be fairly quickly. The thing that you want to be able to do is make sure that you can prove that you've done the filing so that any disclosures you make in that period of time do not undermine your rights. The whole idea is, the idea is not the provisional. The idea is the non-provisional and the eventual commercial exploitation of the technology. It's kind of like getting in line at the movies, you know, you just wait until it's your time to come up to the window. But before you get up to the window, you have to stand in the line. And a provisional patent application gets you in that line. So when you're in that line, your technology is protected. And that's what you want to do. So when you're on that line, you can publish, you can offer for sale. When you're in that line, you can get venture capitalists involved. You can go to a trade show and show it. You can develop your own prototypes and sell them, okay? Because you know that the technology is protected, okay? Yes?
And then, do they ever not give the provisional?
The question is, do they ever not issue a provisional? I would think it's theoretically possible, but not for anyone in this class. Okay, I imagine the USPTO, I imagine they can tell you stories. Maybe Mike will tell you some of the stories. Ask Mike when he comes on Friday, because I'd like to know the answer to that. I imagine they get some things that none of us in this room would believe. So I guess the answer is probably yes, but I doubt that it'll come from anybody in this class or anyone in this institution. It's really so easy to get a provisional. You don't really start getting into the nitty-gritty of patent prosecution until you file a non-provisional. That's when you're talking to the examiner at the USPTO about every word in your claims and every one of the dependent claims. That's when things really start to get serious, okay? Think of a provisional as a placeholder more than anything else. It's no good to you if you allow it to lapse. So, what good is having a provisional, quite frankly, other than to attract funding so you can go the non-provisional route? But if the idea is to just get a provisional and end it right there, then, there's really almost no point in going through the exercise. The provisional is to get your foot in the door so that you can protect your technology as you begin to wait in the movie line, of people going for non-provisional patent protection. What you want is 20 years of protection, but you're better off starting at the provisional so that you don't have to do all of this work, and you can get as early protection as possible, and you can publish and disclose and get money and not lose your rights, okay? Do you have, yes?
So if you file a non-provisional, how soon do you suggest to start the provisional?
The non-provisional?
The non-provisional.
It's like Goldilocks, all right? Goldilocks, the soup was too cold, the soup was too hot, the soup was just right. The answer is it depends on the circumstances. If you have unlimited resources, if there's a lot of work to be done, if this is complex technology, then my advice is going to be, okay, we filed your provisional, now get to work, okay? Because we only have 12 months to get this done. But if you can roll out of bed and do the illustrations and the claims, and it's not a complicated technology, and it doesn't cost a lot, and you don't have a lot of money, I'm going to say, well, you know what? See if you can get some investors. All in due time. So it depends on the circumstances and the wherewithal that you have to bring this on to market. Some people have lots of investors, and and other people actually like lawyers and draftsmen to do the work. And if you can do that, the sooner the better, right? And it makes sense if you've got a technology that is a winner. For instance, 3D manufacturing of confectionery food items. Boy, if anybody could think of how to do that, right? How could I print a Hershey bar right here? I don't like that. A Nestle's Crunch bar right here. Wouldn't that be great? All right. So some people with access to that sort of technology might want to do it sooner than later. Okay. It's a little bit like an exam paper or a term paper. The longer you put it off, the worse it kind of gets. So my advice to clients is always to get to work and try to do this the right way. Not trying to bite off more than you can chew immediately. And once you file the provisional, to kind of begin thinking of the non-provisional. And what am I going to need to do? where am I going to find an illustrator? Where am I going to find a graphic artist? Where am I going to find someone to write a claims? There's that guy teaching a class over at MIT that might know some lawyer that can write claims for me. Maybe I'll call him. That's the kind of stuff that you need to sort of start putting, but it depends on the invention,
And follow-up question, do you need an actually working prototype fully realized in order to file a non-provisional or not? Just the drawings are fine.
You just need to be able to demonstrate through your description that your invention has, what's that word? One of the 4 things you have to be able to do, what the CRISPR people weren't able to do: utility, novelty, that it works, okay, that it does something, okay? So again, it depends on the invention, whether it's aqua blades or or a mousetrap. You have to be able to demonstrate that it does what it's designed to do, or it doesn't qualify for patent protection. It's missing one of those 4 elements. If it doesn't have demonstrated utility, you're out of luck. Remember, what are the 4 elements? It has to be statutory, right? It has to have novelty. It has to have utility, non-obviousness, right? Okay, so all of those things, if you miss any one of those check marks, you're not going to get protection. And so I suppose, a provisional has been or will be rejected by the USPTO if it doesn't, have all 4 of those boxes checked. But I have a hard time imagining anybody in this room that would be the victim of that. When a provisional patent application is filed, the USPTO places the application in a queue. We already talked about it. It's kind of like a movie line to go to the movies. That's how I think of it. The average wait time is 24 months. And after examining the patent application, the examiner will then negotiate with the inventor's patent attorney during what's called patent prosecution. And if the examiner is a charming, intelligent attorney are able to come to an agreement, the examiner will allow the application to issue to a patent. The average time is wait 3 years. By the way, as a postscript to our story about the student in this hypothetical university in Cambridge that everybody's heard about, who invented the hydrogen generating machine, they just got their utility patent approved by the USPTO. They own the technology now. And it looks like this institution, which will remain nameless, may actually do the right thing now that they've been urged to go in that direction by the lawyers who represent the student. So our story, which I said I keep coming back to during the term because it was developing, has had some good turns recently in favor of the student. One of them being that the USPTO has granted the student a very valuable patent on the technology, which is really great. It's nothing better than opening up the mail and opening up the USPTO letter and seeing that the claims have been approved by the USPTO office. It's kind of a cool thing, a real landmark for an inventor. The next step is making money. So another advantage of the 2-step approach is where disclosure is needed before the invention is completely developed. We already sort of talked about this. Patent law encourages the filing of a patent before certain events, such as the public showing or an offer of sale. So if you are on a deadline to make an offer of sale or a public showing, you believe that you're going to further develop your aqua fins or your mousetrap or your gene editing technology, then the right thing to do is to file the provisional before you do any of that stuff. And then you can do it in complete and utter safety, knowing that your provisional is on file at the USPTO and nobody can jump you in line, to further my awkward analogy. So the two-step approach reduces the filing fees and the cost. I've put together a hypothetical. This is actually kind of a real-life example, except I think when I first started using it was when attorneys and illustrators got less money than they do an hour now. But consider the example. Very simple invention might generally cost $5,000 in attorney's fees to prepare a non-provisional application. So the filing fee is for a non-provisional application they have micro entities, small entities, regular entities, and big entities if you look at the patent application. So it was about $530. So the total cost of filing the application, if you just go straight to non-provisional, is, that's wrong,
Yeah,
5,530. Okay, so I've been making that mistake for 5 years. So, I mean, you know, what's wrong with me, first of all, but what's wrong with everybody else who's let that go by for 5 years? All right, anyhow, so imagine I added it up right. It's 5,530. Yeah, you know, the only thing I got right was the attorney's fees part of that. All right, so now let's look at the two-step approach using the same sort of scenario. Let's assume that it costs $2,500 in fees to prepare the claims for the invention. Since claims are not required in a provisional application, that reduces your attorney's fees by $2,500. The filing fee for a provisional application for a microentity, when I wrote this, it was $125. I think it went up last year. It might be $142 now, but you know, it's much smaller than for a non-provisional. And therefore, so the total cost to file the provisional application is $26.25. I think I got this one right at least, because you save $2,500 in legal fees, and you save another few $100s in the filing fee. Obviously, a really simple example. There are other things you save. You know, illustration the cost of illustration, time, your own time. I don't know about yours, but mine is valuable. At least I like to think so. So, you know, this going a simple route gets your foot in the door for much less money. And that's why many inventors go that route. A non-provisional application claiming the benefit of provisional applications that went before it must be filed within 1 year. We're at this point almost beating a dead horse. I'm thinking you must like say these things in your sleep now. 1 year grace period. Have to file within 1 year. If you go out of this class knowing one thing, I hope it's at least that. So the cost of, assuming there's no change in the invention and no change in the application content, when you file the non-provisional, the cost of drafting claims would be the extra $2,500. The government filing fee for the non-provisional is $530. Therefore, the cost of the second step, filing the non-provisional, is more than it would be if you went the one-step route, $3,030. So under the two-step process, the cost of the application is split over 2 years' time, okay, for the provisional plus the non-provisional. So as you can see, the two-step process costs an additional $125, which is not incurred in the one-step non-provisional process. Therefore, in the example, for a very simple invention, you can see that for an addition of $125 to the overall cost, you can save attorney's fees and pass that money on to your investors or your parents or your crowdsource. You don't have to come up with the money. And you know, I use $2,500 here as an example. A lot of you may be sitting there going, well, you know, I could probably, you know, raise $2,500. But you know, the real cost of these things can be, you know, maybe 3 or 4 times that. So on a simple invention, you know, you're really talking nowadays at least $10,000, maybe $20,000, you know. And if you can get non-provisional done, you know, for $10,000 or $20,000, you know, that requires some serious outlay. And if you can do a if you can do a provisional for just a few $100s and save all that money for after you get the provisional and hopefully have attracted some inventors, there's a real advantage to that. So not only does it really cost less to do a provisional, that year allows you to get the money from either working yourself or from investors. But passing that cost on or extending it out a year actually is a big advantage for some inventors, for most inventors. So applying for a non-provisional patent, these are just the things that you have to know. Higher filing fee, more complex and sophisticated drafting, both illustrations and engineering drawings. A specific application format is required. Remember, we talked about how there are no forms when it comes to provisional patent applications. You can do it on your own piece of paper so long as you use the USPTO cover sheet. But with a non-provisional, there are very specific application formats required. You have to do claims. You have to have a declaration. Informed disclosure is required, an ISD statement. Anybody know what that is? An ISD statement is a statement that has to do with government funding and other inventors. You have to disclose to the Patent and Trademark Office who else is involved in this technology. So you have to disclose all inventors and if there's any government funding involved. Again, part of their job is to enforce things like the Bayh-Dole Act, which states that if government funding is involved, the government gets a piece of the action, or at least gets marching in rights when it comes time to commercially exploit the technology. And if not precluded by prior art, and by the way, with a non-provisional, you have to do a prior art search, and that costs money. Most people nowadays hire a firm to do prior art searches. It's more efficient rather than do it yourself. But in any case, if not precluded by prior art, and if adequately explaining the invention, a provisional will mature into a non-provisional, and that confers the right to prevent others from using the technology. Non-provisional application should not only provide a technical description, but should also do so in the context of prior art. Has anybody gone on the USPTO website and just kind of rooted around on there? I really recommend that you take 15 minutes today and go on the USPTO website and just play around with it and take a look at prior art. Punch in something like running shoe or aqua blades if you want, or something of interest to you personally. And just kind of mess around on there and see how easy it actually and user-friendly it is. I really recommend it. It'll demystify a lot of this stuff for you, especially how you file a provisional or non-provisional patent application. It's all done electronically now, and I recommend that you go on the site and just mess around for a little while, see what you can learn. In fact, you can do that, or you can take a look at the slide presentation online and read all about the significant Supreme Court decisions I've put up there. But I'm going to let you go a little early so that you can't say next week or next Friday that you didn't have time to go on the USPTO website. So unless there are any questions, that's it for today. Remember, Friday, Mike McGurk is going to come in and bring your questions. I told him that he should come up with a presentation about the pitfalls, the trials, the tribulations, the traps for the unwary, having you all in mind. So that's what I told Mike. What I want to tell you is to come in here with challenging questions for Mike, because we all learn by questions. I mean, I think the only time anybody really learns is by listening to others have a dialogue. Remember, I talked about education being the accidental byproduct of discussion fueled by curiosity. And I really think that, by the way, that's a copyrighted phrase. But feel free to use it. But I really think that questions really help everybody to learn. So so I've told Mike what he needs to be ready to do, but I'm asking you when you come in on Friday to have some questions ready for Mike, even if you can't imagine anyone would ask such a question. Put it to Mike. Don't be afraid to ask him. We'll all learn from it. Okay? So thanks for coming. No questions. See you on Friday. Free Bagel Friday.